from Senior Counsel in Law Group LLP US, and the panelist is Alex Lang, International Partner, Angie Board Law Firm from IP Paralegal China, Simul Judge Partner, Page White Ferrer from UK. I welcome them all.
Good afternoon, everybody. So no pressure, we're the last panel before UN Happy Hour, but I'm sure we have a wonderful discussion here for you guys. So thank you for hanging with us, thank you for your time, and let's get started. So our topic today is the green IP revolution, sustainability and IP in the circular economy. So as everyone here knows that we're at a critical point in this world where we're all dealing with challenges. Environmental challenges are very pressing. There's a constant need for green solutions. I'm sure you've seen lots of companies are investing tons of money, tons of resources to come up with better tech, better strategies, and these are the things people are really looking into both at a company level, but also at an individual level. So what we're gonna do today is IP plays such a crucial part when it comes to sustainability. And our distinguished panelists, Alex and Sam today, they bring a wealth of expertise on these topics, and they are going to walk you through a robust discussion on sustainability and IP. So with that, let's get started. My first question is to Sam. What are some recent trends you've observed in the green tech space?
I'm joining you today from Page White Farrer, and you've seen my colleague Jacob on stage in our very first session this morning. So I work on the chemistry side of the firm, where we're heavily involved in sustainable technology, and we have recently had a very significant amount of growth in terms of the number of clients who have been approaching us about chemical inventions, which is very, very positive, both for us and hopefully also for the world with the move towards net zero. The particular areas where I've seen growth have been in material science, where, for example, we have new materials for batteries, we have new materials for more sustainable packaging, and we have new materials that are being used for carbon capture and storage, as we saw in one of the presentations earlier today. So yeah, the story is really one of growth with a particular focus on materials, and I am hopeful that this trend is going to continue because the move to green technology is one of the main areas that the UK government is investing in. So amongst the five areas that Innovate at UK, the government's investment arm, have identified, net zero, healthcare, and AI are the top three. So I'm very hopeful for the future. So Alex, are you seeing the same sort of trends in China?
Yes, definitely. Yeah. First, I would like to clarify that my firm is Angie Law Firm, and nothing to do with the paralegal. That's just because my paralegal registered for me, and so her title is paralegal, so we'll put it at the end of the law firm. So it looks funny. I know it's confusing, and somebody asked me about that. And so I have a mostly telecom background. I worked in Huawei before I came to study in Northwestern for my JD degree, and I worked as a US lawyer. And I come back to China as the IP head of a GD car, which would be helpful to the topic today. Because the thing I noticed for the last few years in China is that in the renewable technology, China is really making sort of expansion. I would say very fast technology progress, yes, and very fast increase of revenue, and the fierce competition between the Chinese companies. I read one article on Financial Times, the UK magazine, about the what is the fastest growth European company in the last few years. And I think, oh, that's interesting. So I check that. And it turns out the fastest growing European company in the last few years is one distributor who says that there is a chance of purchasing photovoltaic cells from China and sell it in Europe. And so this, I think there's someone from Central Europe and sense a business opportunity and get rich very quickly. And this is one good story. And they see that the potential of the China supply chain, how to rapidly change the market. And in general, what we can see that although there are such quick revenue growth, it's like I think that company is like 5 times per year for quite several years. You imagine that for your law firm. Then, and the China itself, those companies, they are losing money, and because the competition, they are all selling near the cost or even below the cost, and the result is that there is lots of litigations among them. I think we will cover that later, but I'll leave it here. So what I've observed is that explosive supply from China, both quickly getting technology more advanced, and in terms of getting the expansion of the production, but the company are not making money, and they are sort of see who will survive at last.
Yeah, that's very interesting that you mentioned the batteries, Alex, because it's, Sam, sorry, you mentioned batteries because part of like our trend towards using renewable energy, it's all going to rely on battery technology. And how is batteries going to move forward from a storage perspective? I'm sure everybody here heard about when Texas had that blackout last couple years ago. There was certain sections where they were able to employ battery technology and have that kind of energy storage. So on one end of the spectrum, you have the race towards having renewable energy and sustainability, and then on the other hand of it, you have storage, because you could have all this wonderful energy, but if you don't have means to store it, then it would not lead anywhere. And the second aspect of it that I find interesting is also costs. Like solar panels are popular, people want them, but currently the cost of solar panels is just so expensive that we can't necessarily wrap our arms around it in a way that the everyday consumer can have solar panels. We can, folks that live out in Nevada, California, Southern California with a lot of sun, solar energy, like how do we capture that? So interesting aspect that we brought up about batteries. And Alex, you mentioned about China and the competitive pricing. I think that's a really good segue into this next question I feel like I want to discuss is related to US-China relations, especially in election year. Can you talk a little bit about how do you think this is going to impact the green tech space, and like what do you see as the outcome of it? Because a lot of supply chain, as you pointed out, is built around China, and that's where our tech is manufacturing. So what do you see as the impact on this?
Yeah, that's certainly a very good question. I'm sort of all for the anti-global warming, that we should do something to protect the globe. And I think China is doing good things about that by driving the cost of the solar panels and the cells down very much, to the point that they are losing money. And I can also see the concerns from the US and both Europe that China is taking jobs away from those workers working in this area. But overall, firstly, I think it's a good thing. And then I think because I think China, honestly, is technology more advanced than other countries in these areas. That no, it's not, their costs are down because they are using new technologies for the area. So now the Earth needs this technology, and there is a legitimate sort of concern of how to they don't protect their jobs in domestic market or domestic within this country. It makes the political sense for politicians, and it makes sense for the workers. So one way to do it, I think right now is maybe China would license IP to those countries and help them to build factories. Like 10 years ago, 20 years ago, US companies and European companies help China build the Chinese factories. And one is already doing that. My client, CATL, is a car battery manufacturer, is helping Ford build their battery factories in the United States. And the IP is concerned here because like all IP owners, CATL is so concerned that they will lose their edge of IP. They want to earn the money, right, to get paid by IP. But they want to make the battery, right? But they don't want to say, okay, we transfer this IP to you, or we reveal the trade secret, so you catch up quickly and compete us in other markets. So there is, I think CATL tried very hard to allow Ford to build a battery factory, run on their own, and but at the same time, still remain advantage of the IP, and mostly I think in the form advantage, the trade secret. And another thing is, I think it's just generally good to allow those goods to have a free flow in the world, because that's just as I said, the Earth needed, and for the climate reasons, we better to have allowed the cheaper goods, the cheaper solar panel, the cheaper batteries, cheaper wind turbines to be sold around the world. So I think right now it's just okay for Europe to impose a 20%, 30% tariff on the Chinese cars because they are using most of it as batteries. It's kind of very extreme for the US to impose like 100% tariffs on the Chinese EV cars. And I'm kind of a pro for the competition. So I would like to have a more fierce competition in these areas, drive the cost down, and like to make the technology have a more adoption worldwide. But as far as we can get, I think if we don't get it, IP licensing seems to the way to get this technology adopted around the world, without trigger lots of political backlash.
Yeah, absolutely. I feel like the point that you've brought up about CATL and battery production, like we're at a stage where we need batteries, and there's this national level tariffs or relationships going on, but then there's also this elevated global level need for certain things like, microchips is another one, and having that kind of manufacturing capabilities and leveraging maybe licensing or understanding collaboratively that these are technologies that we need to work on. This is something nationally needs to be worked on rather than have tariffs. Alex, that's been some really great points. Sam, do you have anything to add?
I just want to say that I agree with what Alex was saying on that competition is important because competition is part of what drives innovation, and it's what stops us from stagnating. So I'm not an expert in economics by any means, but applying 100% tariffs to me sounds very to some extent perhaps counterproductive if we're trying to drive towards cleaner technologies. Perhaps Europe and the US should be competing on technical innovation rather than just high taxes.
Yep, absolutely. Nothing's promised but death and taxes, right? Tariffs is part of that system too. So it's going to be very interesting to see how things are going to pan out from this perspective. But my hope is, you know, I'm very pro EV, and this is coming from someone that has driven every car on the lot that you can imagine. And I was not pro EVs before, but after I got in my first car, my first EV, it was a Tesla. And I was like, oh, they're sluggish, they're slow, they work on batteries, like how is this gonna work? I am a believer, a complete converted EV person. And those cars need batteries, those cars need chip. And that's kind of like, you know, the pie, it's not a zero-sum game when it comes to renewables. It's not, there's opportunity for everybody here, and it's opportunity for us to all nationally, all nations to move towards sustainability. So I think hopefully we'll get there. So moving on from this topic, Sam, have you encountered any special challenges when you're prosecuting applications related to sustainable technologies, like these interesting and very important ones?
Yes, and specifically to applications that relate to the circular economy, because it adds in an entirely, it adds an extra category of claim to think about. You need a further independent method claim. So if you're claiming the material, you're also claiming the use of the material, the method of manufacturing the material, and then also the method of recycling the material to fully cover all of the aspects of the client's invention. And all four of those categories might have a different chemical scope. So for example, you might be able to define the use of a class of material that is broader than the materials that you're defining in your pure product claim based on the available prior art. So the applications in this area tend to be quite large with many independent claims, and you always have to be very careful to explain to the client that there are likely to be problems with unity of invention, and there is a relatively high risk of needing to file what you would call in the US, I believe, continuation applications. For us Europeans, we call them divisionals, but there may be a need to split a big application into several in order to get full coverage for the invention. And that's really the issue that I've noticed that is specific to circular economy cases.
How about you, Alex?
There is an interesting case earlier this year in China. And there's a case about my client successfully invalidated a patent about photocyclic cells, and that's by ATL. That's the battery manufacturer I mentioned earlier is CATL. That's ATL. They are sort of related company but independent of each other. So the patent panel found the patent to be 0.1% too broad. The patent is the scope. Why I said that? Because the specification said there is a range. It's better to be from 0.1% to 10%, and the claim is claimed to protect 0 to 10%. So there is a difference of 0.1%. So and why we say that? I don't know what they think about it when they expand the scope a little bit, but the result is that the whole patent is invalidated, because the patent panel ultimately held that the claims were not well supported by the specification. You can't explain the difference of 0.1%, and there is no way to cure that. You can't say, okay, I can shrink it now. You can't do that in China unless you get it. Mostly you need to get it into a dependent claim, or you need to get it supported somewhere in the specification, but by some rule, you can't do that. And so they lose a very valuable patent. So any patent, as you would know, that you can be relied upon to sue a competitor is extremely valuable. And because, I don't know what's the reason, they try too smart to get a little bit broader, the whole patent was invalidated. So it's, I think the lesson is that you'd better, as a patent prosecution lawyer or agent, you better be very careful about that. Is that what that means? I think if you want, if I did some patent prosecution work. If I was that, I couldn't sleep on that because it's kind of like career ruining. And you'd better check with the client. Are you sure you want that? Just a little bit.
Interestingly, we've had similar sorts of cases in the UK within the last few years. I don't think it was issues with support, but rather it was novelty, where the rounding error on a range was crucial to whether or not a product infringed. So I agree with Alex's comment that when you are defining an application, when you're defining ranges of parameters, you have to be very careful that you're defining sensible ranges and that you've got some robust dependent claims to have the option to be able to narrow down to something that's quite close to your examples if you run into problems, be it with support or be it with lack of novelty because of close prior art. And we also have in Europe, I think possibly similar to China, very, very strict restrictions on the ability to amend claims. So in the US, as I understand it, you just need support for your amendments, whereas in Europe you need direct and unambiguous basis, and that is a much higher bar. It's not very much more liberal than needing explicit word-for-word basis for the wording of your entire claim, so that all the features that you have in your claim 1 are disclosed together somewhere in the application, and that's something that we always take very great care about when we're drafting applications.
Very fine line, huh? When you're drafting these to capture what you need to capture while managing these types of risks. Okay, so talk to us a little bit about, is the patent system providing enough support for applicants that want to protect these very important inventions?
So the amount of support that's specific to green tech companies, I think, is fairly limited. In the UK, we have what's called the Green Channel, which is accelerated examination, where you have 0 official fees for it. You just have to write a short letter to the examiner explaining why your application is beneficial to the environment, and that's all very well and good in theory, but in practice you still have to get the examiner on the telephone because the requests seem not to be processed unless you follow up on them, and that was quite important to one of my clients whose priority year was ending, and they really needed their search report to be able to make a decision on whether to file overseas. But the UK is otherwise is nevertheless still a very friendly, quite in my opinion, a very friendly applicant-friendly jurisdiction because our official fees are very, very low. The standard of search and examination is very high. In Europe, there's very little. So at the European Patent Office, there's very little that's specific to green tech companies, but one very helpful new scheme for startups and small businesses, so businesses that have got fewer than, I think, 10 employees, or that are generating less than 2 million euros of revenue, and who have filed fewer than 5 applications in the past 2 or 3 years. I need to go away and check that number, but there is a reduction of 30% on all of the official fees for applicants who meet those conditions. So we finally have something that is a little bit similar to US small entity status, and that's very, very new. I believe it entered into force in April of this year, and it's very good to see, because so many clients in this space are startup businesses who really do benefit from any kind of fee reduction that's out there.
Yeah, it can get very expensive too. So while there's a lot of value add here, when you're a startup and you're bootstrapped for cash, that is something, even though understanding that IP is important and you need to protect, I can see the hesitation in wanting to do that. So it sounds like that's really great to have that reduction. Sam, is that reduction only for sustainable green tech, or is it for all of them?
That's for all applicants who meet the size requirements.
Okay. Any thoughts, Alex, on the same question related to support in the patent system?
Yeah, I don't think there's a particular support other than you can have expedited application, but that's along with other like AI, telecom. I think there is quite a few technology categories that you can try to have a sort of speed up your application, and it's something. I think the Chinese support on this kind of technology are more through the sort of the government promotion of the business. It's like give you very cheap land, give you promise you to reduce your tax, within certain years, something like that. But within the patent system, I think the only maybe expedition procedure, but that's it.
Okay, so it would be more like governmental support for the company from a funding perspective or tax breaks rather than at the patent system level.
Right. Oh, I think one important thing is that there is very strict license quota in big cities in China for your cars. But if you are driving an EV car, it's much easier to get that license plate. So that's a very big incentive for EV cars.
Wow, that's very interesting incentive. That's pretty cool.
That's why I didn't have a car. I still don't have a car.
Well, we gotta get you an EV, Alex, so you can get your license plate too. Yeah. So you've both been doing this a while. Over time, what has been your experience in terms of like how have things been changing? What are some observations that have jumped out at you in your years of practice when it comes towards this type of technology?
My practice has historically been and continues to be very diverse. So I work across quite a lot of different technical fields. One thing I have noticed is that even in the pure chemistry cases that are more my focus, clients are interested in capturing AI aspects. I'm lucky in my firm to have software experts like Jacob, and also my colleagues at our Leeds office, who are able to give me some advice when a client comes to me with, for example, a process invention where actually the software for controlling that process might support a separate independent claim. There is a lot more interdisciplinary work than there used to be when I first started. I think that's the main shift that I've seen.
How about you, Alex?
I didn't fully develop this, but what I observed is there are much more litigations in these areas, patent litigations, trade secret litigations. I think in the past years, I've observed Korean companies suing Chinese solar panel companies in ITC and district court, and I think Siemens sued GE in Florida, then transferred to Massachusetts for patent litigation, and then won the jury verdict at least, and then they settled. But recently, it's more about the Chinese companies suing another Chinese companies in US and Europe, and of course China. And yes, and for China, they can get injunctions. We'll talk about that tomorrow. And it's for in Europe, I think recently GE asserted patents in Germany. I'm not sure whether that's unified court or not. I guess two Chinese companies, one of these my clients, and in Eastern District of Texas, ATL, the company I just sent to get the patent invalidated, is using my client. They won a case. My client lost the case already. Now they're hit by another case from ATL for patent infringement. My client countersued for antitrust, but I think they lost that claim. So they are all now sort of, because as the price war I mentioned earlier, the market is getting so competitive, and the companies began to think, what else leverage can I have now on my competitors beyond just lowering my cost or lowering my price? And then they look to the patents and see as a way of their stand out. So, my solar panel client, although not involved in any litigations right now, is super anxious. And so I'm updating them monthly of what else is happening in those litigations, so they are watching. And my client in battery, as I said, is getting sued all over the world right now. And so they are constantly talking with law firms all over the world, from Germany, from the US. So it's like, oh, yesterday we talked with this firm and this. You look at the Word 50, and you get all the big names law firms. If there is no conflict, they probably have talked with my client already. And so I think the trend is very clear that the companies, they are seeking anyways to help them to survive this very fierce competition. And we'll see the results. That's kind of interesting. I think it is the first time that we see the large-scale litigations among Chinese companies, worldwide, in U.S., Europe, and China. And I don't think I have seen that before. The telecom industry, Huawei and ZTE have been active, but they're both in Shenzhen, so Shenzhen government sort of forced them to stay in peace a little bit, but for this green tech, this competition is, and the competition is so fierce, and they belong to different provinces. So local government have less leverage on them, and they are using all legal courses available to try to get survived.
Yeah, that's very interesting, because I would not have thought that Chinese companies would sue other Chinese companies all over the world. Like, that seems unusual, but anything to get that leverage and get ahead. And it's very interesting because on one hand, you're trying to reduce costs, you're trying to get your product out and be popular, but on the other hand, competition is good, and yet there's so much going forward to stifle competition as well, and innovation when it comes with it. So as I mentioned before, it's not a zero-sum game. Like, there's a big pie for a lot of them. It must be very interesting to be focused in on innovation and your products and getting them more out there, while also being worried about getting sued in Germany tomorrow, and sustainability, right? Like, long term, a lot of these companies, companies like CATL are big, they have the resources and the budgets to fight it. But if you're a smaller company that is making these really crucial innovations that are going to be helpful from an environmental perspective, and yet you're like worried, it could have the false impact of like stifling those sort of companies rather than us having to uplift exactly those type of companies. So that's very interesting aspect of it. Any practical tips either of you would like to share with the audience?
Yes, there is one. Well, kind of two issues, but they kind of run together. And this is a way to work around the scary direct and unambiguous basis requirement that we have in Europe. So European examiners understand multiple claim dependencies, far more easily than they understand a statement in the detailed description that, for example, in some embodiments, feature X is present. I know that under US practice, multiple dependencies are very unpopular and they incur very high fees. And a clever workaround that I've seen from some US colleagues is to put in a copy of the claim set into the description in your initial filing as numbered clauses with multiple claim dependency language. And that makes prosecution in Europe so much easier. And what you can also do in that section, in those numbered clauses, is to include additional features because you're not tied to any particular claim count, so you can put in as many clauses, as many statements of invention as you like, so that you have direct and unambiguous basis for any combination of useful features that you can foresee at the time that you're drafting the application. So it frees you from having to worry about formalities, and it lets you capture the invention in as much detail as possible. If you ever find yourself in Europe trying to make an amendment from the description with a sentence beginning in some embodiments or in an embodiment, you might expect a European examiner to come back and say, okay, you're combining features from two different embodiments, this is added subject matter. And the same thing if you're trying to combine together two singly dependent claims. If you have claim 2 dependent from claim 1, claim 3 dependent from claim 1, you try to put claims 2 and 3 into claim 1, European examiner will say there's no basis for that combination, you're added subject matter. And this leads into the second point that I wanted to make, because we had mention of I think it was called a cover sheet provisional in one of the earlier talks this afternoon. The test for entitlement to your priority date, so the ability to date your application back to the date of your provisional filing, you have to have direct and unambiguous basis in your priority document as well. So you need your set of numbered clauses in your provisional filing. Otherwise, your claim to priority might not be valid in Europe. And that's also an issue that you might not find out about until the case goes into opposition or litigation, because examiners in prosecution, they generally don't look at the validity of the priority claim unless they find an intervening piece of prior art. So you can get yourself into a stage where you're in opposition and your claim to priority is invalid, and you have trouble with novelty and inventive step. And so to mitigate that risk, numbered clauses with multiple claim dependency style language gives us much greater flexibility in Europe, and it makes the cases so much easier to prosecute. And that's the take-home point from what I want to say today.
Yeah, that's some really, really good tips there, Sam. Thank you. How about you, Alex? Any thoughts on practical tips for China, Asia?
Yeah, I think so. Right now, it's very clear what those companies want. So I think earlier today we talked about that whether the quality versus quantity in terms of patent applications. When you know that you can get sued tomorrow, it's very clear that quality trumps quantity. It's whatever you have 100 patents you have doesn't equal to the one patent you can put into the complaint. So that's that I think, and so I think all those companies have right now understand that the quality of patent is super important. And secondly, that they begin to notice that the global sort of application, whether it goes through the PCT or Paris, you have to notice that there is kind of a slight differences, because although they look very similar requirements on patent applications, AI is one good example, but in all other areas, what's the written description requirements, what's the enablement requirement, and there is all slight difference in the specification in the claims that 3 years later you found that you want to make that decision correct 3 years ago. So they have to get experienced counsels to look at the local rules of in each country and make sure that you maximize the protection scope of all your patents around the globe. I think that's this company have noticed that, and they look for service providers that can take care of that. That's my understanding of the situation now.
Thank you, Alex. Do we have time for questions? We do? Okay. Any questions from the audience? Everything crystal clear? No burning questions?
I think there was one.
Okay.
Yeah,
Seeing
we have
none.
one question.
Oh, there we go.
Real quick, Sam, you still, the means for, means plus function language, put that in the recitation of the claims?
So means plus function in the UK and Europe is the broadest way to claim a feature, and it covers anything that performs that function. It has very much fallen out of favour, though, because we know about the problems that you have in the US with that type of language. So we try to avoid it as much as we can, and when it is really the broadest way to claim, because I know functional claiming in general seems to not be very well liked by the USPTO. We also claim deeply as well as broadly, so we build as many fallback positions as we can.
So not in the claims, but like in the recitation, detailed description, you still want means for.
Oh yes. For the number of clauses, that could give you better scope in Europe, and unless the US claim language is already broad and functional. There's no. I don't think there's any special meaning. It would vary on a case-by-case basis, but for example, a fixing means versus a means for fixing is probably not going to be interpreted, unlikely to be interpreted differently by the UK IPO. But yes, good question, and the clauses are a good place to put European-specific language.
It's kind of the same in China. That's China is more in the same situation as in Europe.
Okay, since we have no more questions, thank you everybody for your time and attention, and thank you to our panelists for this amazing discussion.
Thank you.
Thank you once again. Now, on behalf of IIPLA, I request a moderator to honor a panelist with small token of appreciation.
Thank you, Alex. Sam. Okay, thank you. Oh, for me too. Thank you.
We can have a group photo for this
Yes.
session. Thank you to all our speakers, attendees for making today such a success. Please join for a final networking break, and we'll see you back tomorrow for another exciting day. Thank you once again.